The judges first, of course, after having received the relevant evidence and the information from the prosecutor, had to take the time to study those pieces of evidence and information, and after having discussed among themselves, they have decided by majority that there are reasonable grounds to believe that the 6 persons are criminally responsible for a number of counts that the prosecutor have presented, and therefore thought that the required standard had been reached for the issuance of summons to appear. Well, they have decided to issue summons to appear because they were persuaded by the prosecutor's argument that at this stage it is sufficient to ensure that those people will appear at trial, and there was no need or reason to deprive those people of their liberty by issuing a warrant of arrest.
The dissenting judge disagreed with the majority within pretrial chamber 2 because of the qualification of the crimes. He had already set out his understanding of the law and the facts in the decision of 31st of March last year, 2010. And after having examined now the applications of the prosecutor together with the evidence that was submitted by him, he was not persuaded that the crimes by the 3 suspects in the 2 cases respectively, that the crimes were not committed pursuant to the policy of an organization. Back in the decision of 31st of March 2010, he had set out his understanding of the law, saying that there is a difference between gross violations of human rights, even if they are committed on a large scale on the one side, and international crimes such as crimes against humanity or war crimes on the other hand. And he did not see, or he was not persuaded by the evidence presented by the prosecutor that the crimes alleged, which have happened during the post-election violence in 2007-2008, reached the level of crimes against humanity. That was the disagreement, and that's why he filed, or he will file, a dissenting opinion in due course, where he will lay out his reasoning.
Well, in relation to the process or the upcoming process, the minority opinion or the dissenting opinion does not actually have any implications in terms of the progress of the proceedings, rather than the judge is showing his disagreement with some parts of law and facts, but it will not impede the upcoming proceedings in any way.
Well, on the basis of the summonses to appear, those persons are obliged to come to the court and appear before the judges on the 7th of April, where the suspects will be read out the charges that the prosecutor intends to present, and they will be informed about their rights, which are guaranteed under the Rome Statute.
If the persons do not appear on the requested date, the chamber reserves the right to replace the summons to appear with warrants of arrest.
The conditions are the same, actually, for the 6 persons in both cases. There are 4 conditions. The first one is not to have contact directly or indirectly with a victim or a witness. The second is to refrain from obstructing or interfering with the attendance or testimony of a witness, or to interfere with the prosecution's investigation. The third one is to refrain from committing crimes. The fourth one is to attend all required hearings at the International Criminal Court. If one of the 6 persons fails to comply with those conditions, the chamber may, on its own motion or at the request of the prosecutor, issue a warrant of arrest. They can amend those conditions either on their own motion, when they see it is necessary, depending on the situation. They may also amend those conditions at the request of the prosecutor. But before they do that, they have to request observations from different persons, including the person himself, the victims, and the prosecutor. So after the initial appearance, which shall take place on 7 April, we start the process leading to the confirmation of charges. This process may take several months. I would say from 4 to 7 months. It may be more, depending on the complexity of the cases, depending also on the challenges which can bring the defense teams. After the initial appearance starts what we call here the process of disclosure. So the prosecutor will have to give to the defense teams the evidence he has collected and on which he wants to rely on for the confirmation of charges. At the confirmation of charges hearing, which could last from 1 week to several weeks, the defense has the right to present evidence. So they may, for example, call witnesses. After this hearing, and the prosecutor has, of course, to present the evidence in order to reach the standard of substantial grounds to believe. The confirmation of charges is the last stage before the trial. If the charges are confirmed, those persons will be sent to trial before a different chamber. Okay? It has to be trial chamber composed of 3 different judges from the pretrial chamber. If the chamber does not confirm the charges, it has other options. The first one is not to confirm the charges, and then the proceedings will stop there. There will be no trial. Another option is to go back to the prosecutor and either to request him to conduct further investigation or to amend the charges because from the evidence he has presented, it appears that there is another crime which was committed than the one presented by the prosecutor.
And actually, what my colleague has mentioned took place actually in 2009 when the same chamber was dealing with the case of Mr. Jean-Pierre Bemba, rising from the Central African Republic. The chamber actually went back to the prosecutor and adjourned the hearing and requested him to reconsider his charges, in particular the mode of liability at the time. And then the prosecutor came back with a different mode of liability, and the chamber later on confirmed the charges on a different mode of liability.
What happens now, the proceedings that have started now with the issuance of the summons to appear are pre-trial proceedings. These are proceedings that precede the trial. It's not the trial. The judges at the end of this phase will not decide on the innocence or guilt of those suspects. But the decision of the judges will be whether or not the prosecutor has assembled enough evidence, so to speak, to support the charges which he is going to present against those suspects. And the judges will decide based on that whether it is okay, so to speak, to go to trial. The pre-trial chamber, the judges will have a filter function where they filter the good cases from the bad cases. If the case is a good one, it will proceed to go to trial. If not, as my colleagues have said, it will stop there.
Those persons are free. They are not detained. So they will come on 7 April, and on 8 they can be back in Kenya because they are free. They are not supposed to stay in The Hague or to be retained here for any purpose other than only the initial appearance. After that, they are free, and the chamber on that day, on 7 April, will announce the first day of the confirmation of charges, and they will have to come back for that day. those persons from now on will have, from the moment of the initial appearance, will have the rights of an accused. Although technically speaking, they are not accused. They will only be accused after the charges are confirmed, if they are confirmed, and they are sent to trial. But they have already all the rights of an accused, especially the right to have a defense counsel, the right to have translation, if need be, the right to have adequate times and facility to prepare their defense. So this is all the rights of an accused. They will only become an accused after the confirmation of charges. It goes without saying that, of course, at this stage of the proceedings, and until guilt is proven at trial beyond reasonable doubt, they are presumed innocent. The 6 persons are for the moment not indicted for the very simple reason that indictment does not exist in the procedural system of the Rome Statute. So indictment does not exist and they will never be indicted. The closest document which could be seen as equivalent to an indictment in the proceedings before the International Criminal Court is the document containing the charges, in accordance with Article 61, paragraph 3 of the Rome Statute. This document will be presented by the prosecutor before the hearing on the confirmation of charges. And it will be presented in a few months, at least 30 days before the hearing on the confirmation of the charges, for the judges to decide, on the basis of this document containing the charges, if the charges are going to be confirmed and those people are going to be sent to trial. It is then on the basis of the decision of the judges confirming the charges, if they are confirmed, that the trial will unfold. There is therefore no indictment in the procedural framework of the Rome Statute. There are now before this court, in the Kenya situation, 2 cases, each case comprising 3 persons. According to Article 19 of the Rome Statute, the Kenyan government can now challenge the admissibility of those cases. However, the challenge has to be based on actual national proceedings. Actual national proceedings, prosecutions, against the same persons and for the same crimes. You cannot challenge admissibility of cases on the basis of future proceedings before eventually a future court or a court to be established. You have to challenge, if you want to challenge admissibility, on the basis of actual proceedings, actual national prosecutions. Otherwise, the challenge may simply not be successful, because that's the drafting of Article 19 and the logic of Article 19. You can only challenge admissibility of a case if you have genuine national prosecutions against the same persons for the same crimes.